Hi, my name's Dan Kent. I'm Research Officer from Brackenridge Institute of Technology. Criminology. This is a report to the Director, Mr Gray, in regards to the introduction of the Organised Crime Control Act 2013, Queensland. Overview of the proposed legislation. The Queensland Government has become increasingly worried about the growing rates of crime related to IMCG and criminal groups. So, as such, the Organised Crime Control Act and the Brackenridge Institute of Criminology has been asked to research the benefits and negatives of the introduction of this legislation. The overview of the legislation proposes to restrict groups of 5 or more people from associating public or private if 2 or more people of those people have a criminal record. In this situation, no crime has to have been committed. The arresting officer has to just believe that or see evidence of any social behaviour risk to public safety. There's a maximum of 5-year sentence, and there is no right of appeal once sentenced. It was hypothesised by the Brackenridge Institute of Criminology that the introduction of legislation will have a detrimental legislative action as it impugns on various fundamental legal rights and principles of alleged offenders. Research strategies focused on government legislation, peer-reviewed articles, media releases, and government law and other reports, specifically aimed at the effects of this legislation on the states. OSLI, legislation.queensland.gov.au, ProQuest, Google, and various other databases were utilised. Also, the eventual outcome of the legislation, the research on the legislation was that this would be a poor legislative decision for the Queensland Government. Research areas of focus that came to that conclusion had an effect on freedom of association, cable principles and natural justice, historical violations of the rule of law and the use of criminal intelligence in the legislation, and criminal activity statistics, media bias and outlaw motorcycle gangs. In regards to freedom of association, the research the foremost legal principle that was actually impugned by the introduction of such legislation is the right of freedom of association. In the case of Australian Capital Television versus Commonwealth, it was deemed that freedom of political communication included freedom of communication between persons, groups and bodies in the community. That is a High Court interpretation of freedom of association laws in Australia. It was deemed by Guy in 2013 that it is unconstitutional, prohibiting individuals to meet together in groups where legitimate issues of concern can be discussed. In line with the principles of freedom of association, the legislation would actively violate the High Court's interpretation of freedom of association laws as it aims to particularly restrict groups of, obviously, people with without committing any criminal activity from associating. Another area which was interesting and which led us to our conclusion was cable principles and natural justice. The proposed legislation infringes upon the cable principles established in Cable versus Director of Public Prosecutions. A state legislator cannot confer upon a state court a function which substantially impairs its institutional integrity. That is, it cannot take away the fundamentals of natural justice from legislation. That is, people have to be found innocent before, people are assumed innocent before guilty, among other things. This was further elaborated in Gypsy Jokers Motorcycle Club versus Commissioner of Police. Legislation which purports to direct the courts as the manner and outcome of the exercise of their jurisdiction would be apt impermissibly to impair the character of the courts as independent and impartial. This legislation confers upon the court specific outcomes already predetermined, which therefore impugns on the fundamentals of natural justice. It also assumes guilt based on association and on an actual criminal act, and therefore takes away from the courts as an impartial adjudicator, and everyone is equal before the courts. This already has assumed guilt. In Queensland, the Legislative Standards Act 1992 states that whether legislation has sufficient regards to rights and liberties of individuals depends on whether the legislation is consistent with the principles of natural justice. Therefore, this legislation directly violates already existing standards for the development of legislation in Queensland. Historically, there's been a lot of violations of the rule and law and the use of criminal intelligence in legislation such as this from various states across Australia. According to the Law Council of Australia, relevant rule of law principles state the law should be applied to all people equally and should not discriminate people on arbitrary or irrational grounds. That is, associating with people, for example, that have criminal records. All people are entitled to their presumption of innocence and to a fair and public trial. Issues such as public immunity and criminal intelligence impugn upon this in such legislation that already exists. In New South Wales, the Crimes Criminal Organisation Act 2009 New South Wales was actually deleted on account of High Court hearings in the case of the Wainaho versus New South Wales. Was actually amended, sorry. In regards to this case, precedent established in the Gypsy Jokers Motorcycle Club Incorporated versus Commissioner of Police proved that the use of criminal intelligence violated the rule of law and procedural fairness. In this situation, evidence utilised by the court may be available to the court, but not the affected parties pursuant to public interest immunity. That being, concerned that such disclosure of this information might prejudice a criminal investigation, compromise the anonymity of confidential sources, and place witnesses in unsafe situations. That being, such information cannot be disclosed to the parties, therefore, due to safety of concerns of witnesses, undercover police officers, etc. That does not give them a right to a fair trial, therefore violating rule of law. Grade 2014 stated that Criminal Organisation Act 2009 Queensland that already exists. In this legislation, the executive may apply for the relevant information to be classified as criminal intelligence in similar already existing Queensland legislation. Criminal activity statistics in Queensland show that OMCG activity is a very small portion of current criminal activity and criminal involvement in Queensland. It accounts for only 1% of criminal activity in Queensland, and OMCG members are found guilty of only 0.17% of offences in Queensland. As you can see from Goldsworthy, that's a very small amount. The Byrne report, which was commissioned to actually research the effectiveness of current laws, stated that between the 31st of January 2015 and starting on the 17th of October 2013, 131,108 persons were charged with offences. 521 of those were members of OMCG groups. The breakdown of offences were only 11% of those offences were violent offences against a person. That's 11% of 521. As you can see also from here, there has been a lot of bias in the media, specifically aimed at police and the OMCG groups, with police getting consistently asked to comment and OMCG groups not having any right to rebut those comments. As a matter of fact, between 17th of November 2014 and the 9th of the 1st, there was 17 articles in relation to OMCG. Only 3 occasions OMCG were asked to comment. There's various limitations in this research. The main limitation was such legislation is a relatively new concept, and it's unable to predict how effective these legislations are in curbing long-term criminal activity. There's also bias of sources. Police tend to come in the media, whereas OMCG don't, and law review articles are aimed at the principles that these tend to violate. There's a lack of peer-reviewed articles actually supporting the introduction of such legislation. And there's obviously very little bias, very little OMCG comment on these effects, the effects that this has on them. It is recommended that the Queensland Government should not proceed with the legislation at this stage, and the Queensland Government should further engage the legal profession and police to come to something that sort of, I guess you could say, does not impute on the legal rights of the perspective of the offenders, but also provides police efficient and sufficient powers to deal with the rising and obviously criminal activity groups.